My friends, a very interesting and important report being released today by the Institute for Reforming Government. It's their 2025 full term in review for the Wisconsin Supreme Court's last term just concluded. It's also a bit of a look ahead for the court with conservative Justice Rebecca Bradley up for re-election next spring. This is a court that has a 4-3 liberal majority on it now. It may turn into a 5-2 majority next year. So how is this newly liberal court doing with their rulings? Well, this is what the IRG and this full term in review report is about. Joining me to talk about it is Jake Curtis, the president of IRG and the Center for Investigative Oversight. Good morning, sir. How are you?
Great. How are you, Jay? So I am General Counsel. We have a
General Counsel,
awesome
right?
President in CJ. Yeah.
Okay. Yes, that's right. General Counsel. So let's start basic here. What's the IRG's intent with this report?
Yeah. And first, thanks for having me on, Jay. Always love coming on your show. These cases. So historically, this court has not put out a lot of decisions over the last two terms. You look back to, even 30, 40 years ago, the Supreme Court would usually put out 50 decisions, 60 decisions a term. Last term, prior to this most recent one, was 14, and then most recently was 22, the number of decisions they put out. So a historically low number of decisions, which has implications. We can talk more about that as far as what the courts of appeals do. Mm-hmm. But, the point is, even with the historically low number of decisions, there's still 22 decisions that you have to sift through. And the court definitely took up big decisions, right? So they may not take up numerically the same number that they have in the past, but some really major decisions relating to separation of powers and things like that. And so what we want to do is we want to look at the last term, look at the major decisions that came out, and really make an objective assessment. How progressive has this court gotten? Are they going in a significantly progressive direction? And at the end of the day, while there's certainly, I think, was maybe some restraint shown by this court, this still was the most progressive court since 2008.
Mm-hmm. The report drives home that elections have consequences, doesn't it? I mean, we had a nice run of judicial conservatism over the last, 15 years or so, but it's a 4-3 liberal court now, and their rulings are starting to reflect it. So, how activist would you say this court was this session? Because they've shown some restraint so far, at least, but, this is both in the cases they choose to hear and then how they settle them, right?
That's exactly right, Jay. And we kind of focused on the word restraint because there are examples where the court maybe could have gone further. But like you said, there's really different kind of phases of the court. 2004 to 2008 was, kind of the Abramson era. And you had, risk contribution theory and things like that were, really extreme kind of judicial principles that were being implemented by that court. Well, we had a change. Like you said, we had about a 15-year stretch of conservative decisions and really the court, respecting doctrine like separation of powers and really focusing on the original intent of actions by the legislature. Well, now we're going in a little bit of a different direction. In some cases, a very significant direction. What we tried to do was to really simplify it. You can really break down the court's decisions by categories. So you look at something like bureaucracy. Well, unfortunately, that's one category where the court has gone pretty hard left. The Evers versus Markline decision really stripped the legislature's ability to pause, object to, or suspend administrative rules, which again, sounds like something really getting into the weeds, but has huge implications, right? The legislature, the people's representatives should have the ability to actually analyze and pause an administrative rule if they think it's going to have too significant of a burden on businesses, taxpayers. IRG polling reflects that. It's frankly a bipartisan issue. Individuals want the legislature to have more ability to oversee the rulemaking process. And unfortunately, the court really has stripped that key legislative committee with a lot of its power. If you look at WMC versus Natural Resources Board, this is a really problematic decision. This is a decision that basically allowed the agency to issue guidance documents that would be, frankly, viewed just like any other law. That's problematic, right? If an agency is going to issue a guidance document, that should go through the rulemaking process. So that would be one example of a category where the court's gone pretty hard left. and I guess I'll finish with one other point. A different category is the gubernatorial veto. So there you have kind of two contrasting decisions. In legislature versus DPI, that was a unanimous decision that basically said the governor can only use his partial veto on an appropriation bill. But then you have Lemieux versus Evers, and I actually think you had me on to talk about this case. This is the 400-year veto case, where in a 4-3 decision, the court basically has allowed the governor that, remember, Wisconsin's governor has one of the strongest veto pens in the country to begin with. And now apparently he can take words and letters and various numbers, cobble them together, and have a 400-year spending increase. It's really an absurd decision.
Well, it is. I would mention that if people want to go through this review, the review is great because you go case by case and explain it, the decisions that they made this last session. You explain the case and why the court's decision matters. I found it thorough but brief enough that it's not boring. Where could listeners find this 2025 Supreme Court in review if they want to find it?
Sure. Reforminggovernment.org has the full report. I believe we're releasing it like this very second. So on your show. And yeah, we would love for listeners to go because again, our audience, anytime we look at a work product at IRG, we are laser focused on what is the audience. We want, we don't want to put out reports that just sit on the shelf. And honestly, Jay, we think about, your listeners, talk radio and your listeners, because they're smart people that care about Wisconsin, direction. And we want to put out work product that people can actually use. And we think this is an objective review of the court's last term. Again, some areas where they maybe showed some restraint, but as you alluded to, if you're looking at kind of phases of the court's history, this is the most progressive court since 2008.
Yeah, and I think we'll get into where it goes next in a moment here, but we're talking with Jake Curtis of IRG, the Institute for Responsible Government. One takeaway from the report, you conclude without overstepping their constitutional boundaries. Quote, the court was able to usher in an emboldened era of progressive governance by delivering on several key decisions that expanded the power of the executive branch at the expense of the legislature. You just sort of explained that with, with the Evers decision, the 400-year veto. I see no way a centrist court would find reasons to, for example, kill off the 1849 abortion law or uphold the governor's 400-year tax hike via partial veto. So those are examples, I assume, that where you'd point to and go, well, this is a progressive court. They seem to be finding reasons to make unexpected decisions.
I think that's a good way to put it, Jay, because at the end of the day, when the court, they may have shown some restraint in kind of some of these more narrow circumstances. But at the end of the day, when they really wanted to see a policy outcome and they could kind of do so without stretching, court doctrine, they did so. I mean, you pointed to the 1849 case. I mean, that was a case I was actually involved in prior to coming to IRG. And it's a really critical case. Set aside the pro-life issue. Many of us, believe in the life issue, and we want to see less abortions, not more. But if you look at the dissents, Justice Ziegler and Bradley do a really, I think, tremendous job pointing out the problem with that decision. And we don't have to get too far in the weeds. Basically, the court said they relied on this doctrine of implied repeal, basically saying since 1849, the legislature has passed numerous other laws relating to abortion. Therefore, the earlier passed 1849 law is repealed.
Right.
That the standard to apply that has historically been extremely high, and that's because the legislature is assumed to know all the laws in the books.
Right.
Now that's an assumption, but I think it's an important one that if the legislature wants to specifically repeal a law, they're going to do it.
Yeah, it's their authority to repeal it. It's not the courts, really.
Exactly. And so, Jay, to your point, it's an important decision, not aside from the kind of the cultural aspect of it, but that's an example, we think, of a case where the court really relied on, frankly, a doctrine that's not used very often. And again, we're trying to be objective. Do we think there's going to be a lot of cases where the court relies on implied repeal? No. But to your point, Jay, I think this was a situation where they could use this kind of narrow principle, use it this one time to overturn a law that they don't like.
Right, that they just wanted to overturn.
Kind of reset the framework. And so from a higher level, 30,000 foot standpoint, the problem is what other doctrines are the courts going to use to repeal laws that aren't consistent with their values?
Well, let's get into some of them. The real progressive wish list is just ahead, right? The newly raised lawsuits related to Act 10 have yet to be heard. This court's liberal members have shown some restraint in not immediately leaping to redraw Wisconsin's congressional maps when asked, but something tells me they won't be so restrained when it comes to Act 10 challenges and maybe pro-abortion challenges coming up.
Yeah, great point. And we wanted this to be a term in review, but we just couldn't help ourselves because we did highlight the Act 10 case working through the Court of Appeals right now, District 2, which is a conservative of the four districts. It's the most conservative Court of Appeals. But that case obviously will have huge implications. And I guess we can break it down if we can just spend a minute here to talk about kind of the two sides. There's the legal side of that appeal. Look, the rational basis review is really critical. In other words, when a court looks at a challenge to a statute, the question is, did the legislature have any rational basis for the law it passed? And again, I think you and I talked about this earlier when this litigation started, Jay. That's an important standard because courts should almost, respect in almost any scenario a legislative act, unless there's no rational basis. And all of us that lived through Act 10 know the struggle that the administration had. They didn't want cops striking. They didn't want jailers walking off the job. Mm-hmm. And so whether you agree or not with that part of Act 10, you can agree there was a rational basis. There was a reason for why the legislature did that. And when you look at the original decision in the circuit court that found Act 10 unconstitutional, it's been stayed pending the appeal, but it's an absurd decision. And again, we try to be objective, but we're going to call balls and strikes. That was an absolutely absurd decision. To say that the legislature and Governor Walker didn't have a rational basis for what they did during the Act 10 debate in kind of separating protective status, law enforcement, is absurd.
Yeah, it's ignoring history.
Raw judicial activism. Right.
This court... I'm sorry, we're sort of running low on time. So you mentioned that this court hasn't, over the last few years, taken a lot of cases or issued a lot of opinions. They took about 22 cases this year when courts in the past have heard as many as 50. Do you expect that to change if there's suddenly a 5-2 majority with members who want to force a new judicial philosophy onto Wisconsin?
Well, that's a great question, Jay. Frankly, that's $1 million question. The question the answer would rest on how calculating has this court been? I mean, are they just really kind of wading in the weeds? And I guess time will tell. That's why this spring's election, we're playing defense, right? Even if we win, the conservatives will just really have the 3, and so we'll still be in the minority. Mm-hmm. But it is certainly possible that maybe with a new justice on the court, they'll become more emboldened. But they may just be selective, which I think is going to have additional implications, right? It makes the courts of appeal, which are typically races that nobody pays attention to, all the more important. District 2, Anthony Lococo is running against Lisa Neubauer. That's a huge race. That's true. If courts of appeal are going to be kind of the courts of essentially last resort, we need to focus more on ensuring that there are originalists, textualists that actually are willing to step up and run for courts of appeal.
Well, yes, and I mean, one very solid conservative justice, Rebecca Bradley, is the one who's up for re-election in spring. There's a question as to whether she's going to run again or retire. It's not a good sign that she doesn't appear to be doing any fundraising currently. If conservatives and small government types lose her seat, this could become, I think, my opinion, a ragingly liberal court. And here's why. It's not just the number of liberals, it's the quality. Karofsky, Dalit, Protasewicz, and now Susan Crawford were all, in my estimation, activist liberals before they joined the court system and before they joined this court. I don't think we just have run-of-the-mill liberal judge who's now sitting on the Supreme Court because they were such a good judge over time. They were appointed to it or were elevated to it by the voters. I think we have Democrats in Wisconsin now that are running judicial activists, and they've managed to get 3 on the court, and this would be a 4th. So
right, and Jay, we point out in our report, it's not just the majority decisions. I think the 1849 case is the best example. You look at the concurrences from somebody like Chief Justice Karofsky. It's basically a manifesto expounding the positive benefits of abortion. Again, however you feel on that issue, it's not the job of a judge to essentially write a white paper. It's hard to even call it a concurring opinion. And so I think, look, the more progressive justices that are added to this court, I mean, it's just natural. The more progressive and the more bold this court is going to be. So it's all the more important that conservatives just at a minimum pay attention to the court, and that's what we're trying to do with this report. And we certainly appreciate you highlighting the report, because we just need to know what's going on. And when even with the historically low number of decisions, when you have 22, 24 decisions based on how you count them, that you have to sift through, what we want to do is focus people's attention on what this court is doing, the fact that it is the most progressive court since 2008, and while it's showing some restraint, if it keeps pushing like it has in some of these cases, and we even talk about a case like Brown versus Weck, where essentially individuals now have very little standing to bring challenges in election-related complaints. I mean, these are really critical issues that the court has really put its thumb on the scale. Right? That was a 4-3 decision, and some really strong dissents there, because on an issue that people really care about, election integrity, the court is basically saying, unless you have direct harm, you're not going to be able to bring a challenge. And that's really problematic, right? The people of Wisconsin care about election integrity, and they should have standing to challenge decisions of WEC or to bring complaints, and now they don't.
Well, I started the interview by mislabeling you title-wise, mislabeled the name of your organization somewhere in there as well. But thanks for being on. Jake Curtis of the Institute for Reforming Government. I think I said responsible government earlier, but thanks for being on this morning.
All good, Jake.
One more time, where can they find this report?
reforminggovernment.org.
All right. Thanks so much. I appreciate it.